Okay, good morning. This is Senate Natural Resources and Energy, and it is Wednesday, May 14th. And we are starting the discussion on 231, H 231, the technical corrections for fish and wildlife. And I believe we have a new draft to look at. And so we'll welcome our legislative council, Michael Lee, up. And one hypothesis here is that we may be in a position to vote this out, which would be amazing. So
That would be fun.
yeah, I'd love to check some stuff off this. So many drafts.
Should I begin?
Yes, and we're just looking at the changes from last time.
Okay.
And we can explain them as we go.
Okay, so you can turn to page 16.
Or just 15? Oh. Sorry, go ahead.
At the bottom of page 16 in section 14, there's the actually it should be 15, I'm sorry.
Yeah, that's okay.
There was the discussion of whether or not to include the word intentionally before take. You had originally asked that it be removed, and that's the department be given authority to adopt rules or directed to adopt rules as to what would be exempt from an unlawful taking. I got direction yesterday afternoon to put intentionally back in and to leave the mandated rulemaking.
So just to explain that a little bit, we did get a letter, which is on our website, I believe, from Colonel Stedman. Thank you, and also thanks for being here.
Well, I just want to make myself available in case we're required.
Yeah, very good. Absolutely. And since you're here, do you want to just paraphrase
Sure.
your letter at all?
Ever so brief, the letter basically walked back the request to have intentionally taken out. And addressed a few other issues that are not germane to this specific
Great.
point.
Yep, and so particularly with that in mind, without there being concerns about intentionally, felt like we could leave it, we'd probably put it back in. So that's where we've left it for now. Any thoughts or concerns about that?
Are you comfortable with that?
Whatever you want.
Well, you have strong feelings. So.
This is okay. Okay.
Okay,
Let's keep going.
Moving on, page 16 of section 14. This was the prohibition on import, possession, or sale of the pond slider. There had already been an exception for a person who had required one prior to July 1, 2015 as a pet, but you wanted to also include an inventory exception, and that is on page 17, lines 3 through 5. The entire subdivision is highlighted because it was just restructured, but the key new term is new language, page 17, 3 through 5. The person with a valid pet dealer permit for commercial collection permit being assessed and sell a turtle that the person can document they have possession of prior to July 1, 2025. So pet dealer, if you're a pet store, you have to have a pet dealer permit. If you're importing for commercial collection, you need a commercial collection permit from the department. I think that covers the regulatory.
I think it's.
And so that's the inventory exception. It doesn't have the deadline date by which they must be sold, but I believe that was where your committee came down.
It says that a pet dealer can sell something after July 125, but a person can possess a turtle only if they bought it before July 125. So theoretically, they can sell it after July 125, but nobody can possess it. Legally, is that a problem?
I think that's up to you. I can amend The language on P 17(1) and 2, a person may continue to possess a turtle that was legally acquired as a pet prior to July 1, 2025. Or a turtle acquired from a pet dealer, commercial collection. On a permittee, under subdivision B.
I mean. Is it dealing with something that's never gonna be an issue, I guess is the potential. I don't wanna overthink it.
Or acquired as a pet prior to July 1, 2025, or acquired as a pet from a pet dealer, commercial collection, permittee B. Under subdivision.
Why we have to have that, I guess.
Yes.
This will happen. Did you guys see my picture that I sent you all last week? As soon as I left here, I stopped at get dog food and there in the store, there was like a huge tank full of sliders, the little turtles. And I texted the whole committee, it's like, look at $32.99 for a nice little, made me a little sad.
I ended up talking with somebody who was an RA down south and how college kids would have all these pet turtles that if people could just like scoop them up out of the pond. There were hundreds of them and then sell them for $20 to college kids who, anyway, it was a
Yeah,
big problem.
wow, interesting.
Anyway. So. Okay. With the aim of voting this out today, if we were to, because I think this is a.
Flag is Michael has it.
Sure, we would say a person may continue to possess a turtle that was legally acquired as a pet prior to July 1, 2025, or acquired as a pet with a pet dealer or commercial collection permittee authorized to sell the subdivision B of this subsection.
I mean, that sounds okay to me, but let's see if there's any other changes that are of interest and we'll go from there.
Those are the changes.
Oh, that's it.
Turtles. I want my turtle earrings. I have multiple pairs of turtle earrings. Don't be worrying about this.
Well, we'll play.
Oh, me too.
Good.
You're my turtle.
Just as a question, I did let Senate Ag know about section 19. About this, taking away this program. Did you walk them through that?
No, I know they took testimony from the agency yesterday on it, but I was not there. I was in another committee.
Okay.
I don't know the results.
Okay, I don't know either, but you know, I didn't hear anything from Senator Ingalls, so I assume if he was wildly opposed, he would have gotten back to me, or
We'll find out on the.
we'll find out on the floor. Also possible.
This,
Yeah, but I did check, yes, I did, yes. Okay. And do we know, I mean, it looks like Senator Beck, his stuff is here.
We know the front.
Yeah,
I saw him earlier.
okay, so, no, yeah,
the bill will go to finance. So if there is. If the community on agriculture was subjected, he probably all address it there.
if there's, if he had concerns,
Yeah.
yeah, okay, that's a good call. We have some other things to talk with. Michael O'Grady about this morning, so what we could do if Senator Beck doesn't appear soon, we could just move on and come back for a vote on this.
So.
Yeah,
Yeah, this thing's ready to go.
actually, on that, I know we haven't actually voted on it yet, just to check in, Senator, well, so the senators are here, how are you both feeling about this?
Good to go.
You're good to go, you're good to go. Just to say it out loud, I think, we may divide up the parts and have different people report different parts. Oh my gosh, he's here.
Hi.
Hi.
Oh, yeah, call me.
Uh-oh, we gained one and lost another.
Oh, yeah, you really do need me on the card.
Yeah.
Yeah, that's it.
Wow.
I
I think we should go.
We're waiting.
But just to say it, Senator Beck, we may divide up the parts of this bill and
Okay.
each take different sections to report, since there's a lot of different aspects to this. So think about which section you might
I
want.
want turtles and fishing.
You want that one? Oh, yes. That makes sense.
Yeah.
So Michael is in on the
Oh, okay.
little face for the fact that you can, because that's it. If you want it.
Okay,
So
that makes sense.
that's it.
Okay.
So I think we need a motion that is to adopt version 5.2
0.0.
with the addition that Michael O'Grady suggested.
But it will still be 5.2.
Yeah, but I will, I can change it to 5.3 if you want, or I can just leave it as 5.2 and change the page.
And she has 5.2.
Sure.
Let's do that.
We'll do that, yeah,
Okay.
leave it as 5.2.
Does the letter from Colonel Stedman require a change to this?
I believe not,
Okay.
but thank you for checking. And just to verify your.
Okay, so do we have a motion for?
I believe we do.
Okay. Okay, are we ready to vote?
I think so.
Okay, Senator Beck, yes. Senator Bonner,
Yes.
Senator Hardy,
Yes.
Senator Williams,
Yes.
Senator Watson.
Yes.
All right, 5-0-0. And
I think I can be the official
you'll be the
reporter,
reporter, okay?
for now, but let's take some different sections. I think, we'll have an affinity for that. Different parts, I should say. So, thank you.
Yeah.
If we can take a second to take that and we'll move on. I heard Senator Hardy wants sections, the turtles and so that's 14, you said?
I think that's the pond slider section, but I'll do all of the first if
So-
you guys want, but.
Before we,
Yeah.
so, are you planning for this to be up for second reading on Friday?
It's gotta go to finance.
Yes, so maybe finance to take it up on by Friday, perhaps.
It won't take it up tomorrow.
Friday would be.
Okay, I was wondering,
Yeah.
I have to do some stuff to do the phone, so I may or may not do it.
Oh, I understand.
But if it's after Friday, it's fine.
Yes, I don't,
Just, I gotta run through it, just if there's a section or whatever makes sense to me.
okay, sure, okay.
All right, thank you.
Thank you.
Yep.
Okay, well, Senator Williams, I was rather hoping that you would take the air rifle section.
Sure. 4 and 5.
Or
3, 4, and 5.
Three is,
use the changing of the one points. And for the shooting from vehicles, which includes the air rifle, narrow rifle.
would you like to do three as well? You were game, Rick. Yeah. Okay, so. Okay, so you've got three. What's that?
I was a real game.
Not a
Let's say the whole game express.
Oh. Counts for something. Okay, so Senator Williams, you're gonna do 3, 4, and 5, is that what I heard?
Yeah.
Okay. Senator Bongers, do you have?
I'll take over.
Okay.
I'll take whatever's flat for whoever.
Um, how would you like to do section 6, which is about violations relating to the use of public waters?
Okay.
Okay. Um.
Yeah, I was trying to this is complicated, because it would be like in and out of sections, which will drive people crazy on the floor if we do too much.
Well, what we could do is say we're gonna divide it up and like you do all of your sections and you do all, but that doesn't
Even if
have
they're
to
not.
be, even if they're not in order. I think that's okay. Just tell people which sections you're covering and,
Okay.
you know, we'll go from there. Do you want any of the other fishing parts?
I'll do whatever you want, really.
Okay.
I don't have to do the turtle section if you wanna do it.
No, you've got, you've got the.
And I'll take as much or as little as you want me to, it's fine,
Okay.
whatever.
I'm not sure. I'm happy to do section 19 about the. There's my goodness, there's a lot of sections.
How about you go through the bill and assign it to all of us and
Okay.
just email.
I think that's a better,
Yeah.
that's a better use of our time right now. I agree. Okay, so I'll do assignments, based on what we've just talked through. Plus a little bit. Okay. Yeah, you got one done. Okay. All right, so, in the spirit of keeping up with what else is happening in other committees, would love to run through, the Rutland Fair language that is currently in 484. The miscellaneous ag bill, we don't have possession of this, but just so that we know what they are talking about, and just for context, we did, talk through accessory on-farm business, changes, to Act 250 that, has since been taken out, so no longer need to discuss that at the moment. But there's this other, and we also talked about the pesticides in here. But we'd love to get this update on Rutland Fair.
Sure, it's on page 27 of draft 422, page 484, with the May 9th. 8/11/01 timestamp. And so when the Committee on Agriculture was taking testimony on the miscellaneous ag bill, they heard from the agricultural affairs and advocates for the agricultural affairs were asking for an exemption from the 3-acre permit for the fairs, and specifically for the Rutland County State Fair. It came to light thereafter that other than the Rutland County Fair, the other fairs subject to the 3-acre, and we're already moving towards getting the permit. And we're intending to comply with the permit. But the Rutland County Fair has unique site constraints, including a railroad on one boundary and a US highway on another boundary. And then commercial and residential on the other boundaries, and there isn't much opportunity for them to implement certain management measures under the stormwater management. So the language started out as a total exemption for agricultural fair from 3 acres, but the Agency of Natural Resources, working with Senator Collmore, they actually went and visited the Rutland County Fair. They looked at the site constraints and they looked at generally what could be done, and they acknowledged that it was a unique situation. And consequently, they proposed this language that's in section 4 of H 484. It does not exempt the fair from the 3-acre permit. They will still need to get the 3-acre permit. They will still need to implement the management measures under the stormwater management manual that they can do. And once they can do all of those that are identified in an engineering feasibility analysis, that will be the ceiling for what they will be required to do. Otherwise, they would have to do an offset or pay a stormwater impact fee. This language releases them from the requirement to pay to do the offset or pay the impact fee. So still permitted, still has to do what management measures they can do under an engineering feasibility analysis. Anything that would be required otherwise to meet the performance goal would be waived. And that's.
Yes.
So, it's typical upstream, downstream issue with the fair. And, the city of Rutland has a requirement for full restoration plan for Mosey Brook, which is in fair law. Until they do that, fair is downstream, there's not much they can do to include the other barriers that are ready to stop with, so, and they understand the need. But they don't have the finances, so. Accomplish.
But and that's another thing, I don't know if the agency has made a specific commitment, but they said that they were gonna work with the fair to try to find financing, so there's nothing specifically on the table yet, but agreement to like work with them on that.
The fair is going to, they come up with a plan, they've already done a lot of work on their own, so if we can do it incrementally for them, it needs to be done, if I understand that.
Well, I'm just so glad that they moved away from a total exemption and that they're gonna be required to do at least what they can. The part about releasing them from any further impact fees is a little bit of a, that's a special case that we're giving to them, but I think given their situation, I'm okay with work, continue with work in this other committee. So any other thoughts on this?
I think it's nice and good scenario and specific to their situation.
Agreed. So would it be fair to say when this gets reported that we are okay with this language? Okay, great. Thank you. Just wanted to check that out. So many bills here. New bills. Okay, and we are up to looking at a new draft of 319, and I believe this, if I'm not mistaken, has both the change to the paint that we discussed yesterday, and it also has changes that Ellen had made yesterday.
Yes, it has three categories of changes. One is to address that issue on the paint program about the convenience requirement and whether for collection, whether it's going to apply to paint product, the expanded term for post-consumer architectural paint, the existing term because of the hazardous nature of some of the paint products. You chose to leave it as the post-consumer architectural paint. The second category was in the contingent effective date for the SALT program and whether or not the A&R report on SALT management was going to be contingent on appropriations. You decided it was not going to be contingent on appropriation, so that was removed from the contingency clause. And then third is what I'll just call the Rygate language, to extend the deadlines for that program, 2020. I didn't draft it, so I don't have it, but I can 2027.
There
So-
are dates.
You should have a draft in front of you, 4.3 with a May 13th date and 452 stamp. If you go to page 26, that's where the post-consumer architectural paint, line 18, it remains how it displays in statute right now, so that collection convenience requirement is going to be there for post-consumer architectural paint.
I think we had wanted to set the other one. Is that what you were gonna say, Senator?
Yeah. I think it's the,
It's line 13 and 14.
yeah. That post-consumer architectural fee, the previous one. should be uncrossed out.
Okay,
That's my understanding, that's what
That's
my notes say.
same,
And that's my understanding from Matt's testimony yesterday.
okay,
right, because we wanted to let the retailer continue to be a collection point for just architectural paint. Not,
understood.
not all paint products. Yeah, and then.
What you did below wasn't actually a change.
No, but it had been struck, and then they asked that it be unstruck,
Okay.
and I said I didn't know if you wanted that done. And that led to the conversation, which led to that not being struck anymore, but now they want the other one unstruck.
I totally hear you, Mike. I hear you. This one was not discussed yesterday, so I think it's just this one. And we were all as confused if you watched the tape. I'm like, okay, Matt, here, look at this. Look at me.
Should I move on?
Yeah, let's move on.
So 64. It's the next. Page, this is the contingency for implementation of the chloride contamination reduction program. It had previously included section 29, which related A&R's report on salt management, and that in the previous draft of the contingent on funding, but you want that to go into effect now or on passage. And so I had to remove section 29 from the list of sections, separate contingency.
I think also in this.
Yeah.
That we were going to just say subject contingent upon an appropriation. And remove in fiscal year 26, because we know it's not gonna get an appropriation in fiscal year 26. So. You know, it's contingent on an appropriation. From the general fund at any date, like if they get it next year, it goes into effect, they get it the year after, it goes into effect. Yes, something like that.
Yep, I think that's how I remember it as well.
Okay.
And. But remind me, can you say again why did we take out section 29?
So that's the report on coverage and
Oh.
management and,
We want them to do that anyway.
right.
Right, that makes sense, yeah, okay.
And then you come to section 33, which is the renewable power portfolio. And moving the date from November 2027 to 2028. And this is Ellen's expertise. You know, my knowledge is that they just seek these extensions of their.
Every year.
Yeah. So, if I think I can give a little background on this, so the draft that we looked at yesterday just had the dates moved that were in 2025. And it had the one that was a typo, which was late 26 to 27, but in talking with Ellen about it afterwards, because we had thought originally there might be some kind of a buffer in the timing so that we wouldn't have to move the other dates back. But Ellen, and we can hear from Ellen too. We've invited her for 10. I'm not sure if she can be here at 10, but if not today, then perhaps tomorrow. But the thought was there was not actually on second look, there was not a buffer. And if we move all of the dates 1 year back now, hopefully they would not come back. We would not have to see them again next year.
That has been said before.
Yeah, gosh. All of this is deja vu for you, huh? Yeah.
The issue that will not die.
Oh, gosh.
Zombie Rygate issue.
Okay. Yeah, so anyway, that was the thought. There was not a buffer that they could absorb that pushback date. If we push back all of them, hopefully they don't. If, you know, and it is kind of a best case scenario, honestly, still, that they're able to meet all of their, requirements in a timely fashion, but. we shall see, but that, it should just all be, pushing back of dates and no language changes.
Right, there had been a version that I saw, and I don't remember what language changes were, but there was some language change, but this is just all dates now.
This is all dates. I do not want to touch any.
Just put in there, they shall not ever come back.
Yeah,
So
right.
that's for extension ever again.
Right, right. That's the language change.
That's pretty.
So again, we can, hear from. We may hear from Ellen, but that's. Yeah, we'll see. Because we're also, cruising right now. Again, we are. So, one possibility is that we. Because it looks like we do need a couple of changes,
I
on
think
this.
back to my office and make them now and sending you the clean copy of this and the 231.
Yeah. That would be great, but did you have something?
Yes, where you go, we actually, looking at we also had both that out in the cold.
Oh, yes.
My class here at 10. And we have at 10:15, my computer.
Watson amendment to walk.
Watson.
Yeah.
I thought that was at 11.
Sorry, say again?
I thought that was at 11.
No, I think we've got it
Well, we have it here.
just contiguous of your, scheduling of your time. So we could just, walk through that amendment before you go.
That's something from
Yesterday.
yeah.
So. Oh, you.
Yeah. The,
Yeah, that's that.
yeah.
That's
But that's.
Oh, it is on this.
That's the other.
Is that yours?
That's one.
Okay.
Oh, okay.
Which one?
It should say, annual report surface water discharges.
That.
Well,
It's like.
Oh, okay. Perfect.
sorry, go ahead.
And this is just a requirement to be added to H 479 and activating the housing for A and R to restore to you. Investigating steps currently necessary to permit new surface water direct discharges of district wastewater in Vermont. Identifying funding sources available to support the construction of such projects. And any recommendations for improving the process. So that permit will involve a couple of different reviews, if it's gonna be actual point source discharge, a new one. They're gonna need a certain type of permit, if it's gonna be a connection to an existing wastewater treatment system, that's a different permit. So it doesn't reference the specific permit because it depends on your situation, depending on what permit you're gonna get.
What are the types of permits one might have at play there?
So if you were gonna, say you were gonna build a brand new development that's gonna have its own mini wastewater treatment plant, that's gonna need a BIPD's, a natural pollution discharge elimination system permit, wastewater treatment permit. If you're going to connect to an existing wastewater system permit, that's actually dealt with under the under the potable water supply and wastewater system rules, the septic rules, that's connections are dealt with there. And so that's what you would get, and normally you just provide both. The whole system there is kind of like what this is about. And how to streamline it and how to do it better. They had a proposal that had been in one of the housing bills, but came out. They've made multiple proposals after the previous few years. So this is like, let's get a formal proposal from them on how to do that, but also to actually address like if a new subdivision, because it's domestic wastewater, it's not commercial, it's not industrial, it's domestic wastewater. If they were gonna build their own wastewater treatment plant, that would be a different permit, but they could address that here.
Okay. Yeah.
Just, given that they had multiple proposals, did you? And this is trying to get them to come back with the one proposal that they think is the best solution. Do we want to ask them to come back with? More specifics, yeah, more details, or like language, or,
They're gonna give you language.
okay,
Brian Redmond, that was the head of the water services division, he's got language.
okay. Alright, so you don't think we need to be more specific, they'll, okay.
I think this is, and I don't know where this came from. I wouldn't be surprised if it came from A&R. And they really wanna formalize this as something that's gonna be proposed, and this is how they're handling that.
I'm fine with it,
Cool.
but also. I mean, if he has language already, I mean, like, should have asked this question sooner than right now, but do they need this language to do this report?
No, but you know, it's a metric they need. And
Yeah.
so something that you require them to do, and then they're going to need to address the issue that I think they want to address, and that some of the people in the building want to address.
Sure. Okay, fair enough. Okay, great, thank you, thanks for,
So I could go to 231 and 319 and send you clean copies.
So this will be added to 319?
or this,
470.
this one, 479,
The
the
housing
housing.
bill? Oh, I see. Okay.
Yep,
That's what.
and actually, didn't check with you about that, are you all okay with adding this language to 479?
You have possession?
We do.
Oh, then it should be drafted differently, it's drafted. No, it's drafted as an amendment from the committee. So I think it would work if that's the only amendment you're gonna make.
We'll see,
Might do more.
and I think we may do more.
Goes, Michael, you suggested you to quickly make the changes to 319,
Yep.
so we could potentially.
Vote it today, that would be amazing. Yes,
Do you want to add the other stuff or not?
to the Rygate stuff, or,
That's great.
we can talk about it, I am, okay.
Other stuff?
That's all.
Spoke too soon, sorry.
Let's
It's kind of, we haven't.
let's move forward with that, making the changes that we talked about.
Okay.
Okay,
Sorry.
thank you.
Sorry.
Maybe,
Okay.
sorry, it took me a second. But we do have, legislative council, Ellen, welcome.
Hello, I'll check out the after legislative council, so. Yeah.
So we have a new draft for 319 that includes this stuff about Rygate. And I did, talk a little bit, about that, I'm sorry, I gotta get back to that, Bill. About the logic for what we talked about. That it includes more date changes than we had discussed last time, because we think there likely is not a buffer for them to, absorb the work. Because they're, rolling deadlines as the work continues.
Sure, so yesterday, Rygate did provide you with proposed language changes, and so their proposal was to move every date a year. And so the draft that Mike just brought you, 319, this language for Rygate date changes are added as section 33, and he highlighted all of that, so it's the last section, and it's highlighted. But there aren't any other substantive changes, just the date changes, so I can walk you through them. So this is amending 30 VSA 8009, which is the statute that governs Rygate. It is specific to just them, And I'll just say, so. The baseload renewable power portfolio requirement is specific to Rygate as a biomass electric generation facility. The other one one of the other ones that's in the state is McNeil. That does not, this statute does not govern McNeil. McNeil is owned by Burlington Electric Department. They use the electricity from McNeil. So Burlington Electric is one of the utilities that is exempted from purchasing the power from Rygate because they have their own source of baseload renewable power. But otherwise, 8009 dictates that Rygate's power shall be purchased by all the utilities. They each get their pro rata share, so based on the percentage of electricity overall that they need. They are required to purchase Rygate's power until 2032 based on a rate set by the Public Utility Commission. That rate was set by the Public Utility Commission years ago, and we've been extending it. Yep, okay, so we have been extending it every time we extend Rygate's requirements in here, and actually, I should draft a further extension because the rate was supposed to expire in 2022. But, so there is a separate piece of language that says that, so I should update that because the order granting the rate is set to expire, I believe this year. And so we should, or it's 2026 when we're moving on the dates. Let me just, so I'm gonna.
Okay, that's okay.
I need to do that. It's a session law provision, so. The PUC issued an order in 2012 granting Rygate a 10-year rate guarantee. And for the last several years, we've been extending that existing rate order. With the idea that after they make the efficiency updates that are required under the statute, the PUC will go through and do a new rate determination. And so, the chair was, I think, alluding to the sort of buffer window, which I don't think we talked about it a lot in here yesterday, but it's how many years that rate will then be in effect. And so as originally crafted in 2009, a few years ago, it was giving them 5 years to get the efficiency updates made, and then they would get a new rate determination. So they would have 5 years of this new rate until 2032, but now we shipped away a few more years of that, and so the first date change here is 2028, and so that is when the new rate will take effect until 2032.
Okay.
So the first date is in subsection D here. So on report November 1, 2028, the commission shall determine for the period of November 1, 2028 until November 1, 2032, the price to be paid to Rygate. That date is backing up a year because all the other requirements of this efficiency upgrades have a year timeline, and so they are spaced on purpose to give time for each part of the process to play out. So under subsection K, Rygate did propose yesterday that the date that has already passed be amended. So just what was currently July 1, 2023 date is being updated to October 1, 2025, because this is them providing a signed contract for the construction of a facility to utilize the excess thermal at the plant, and we need their certification by a qualified engineer that it will meet the efficiency requirement. So they asked for a date change to reflect the fact that they have to resubmit all those documents. Then the next date change is this year, they were supposed to have submitted certifications that the main components of the facility had been manufactured and construction plans completed. That is the date that's being pushed back, so October 1, 2026. That then feeds into subdivision 4 because by November 1 of this year, the if they had not done those prior two things, the PUC was not required to conduct the next rate determination. So that date has also been changed. So that is now back to November 1, 2026. And on or before September 1, 2027, the department shall investigate whether the plan has achieved the efficiency update. And then if they haven't, the department will recommend to the PUC that the obligation to have the power be purchased cease on November 1, 2027. And then the commission will not be required to conduct the determination. So each of these is spaced so that Rite can determine plans for the facilities, submit their plans, have the department review that they have actually met the requirements of the statute, and then evaluate if they have met the requirements and whether or not the new rate determination should be made. After November 1, 2028, the plant owner shall report annually to the department so that they can verify that the efficiency is being maintained. And so that date is being backed up to match when the new rate will take effect.
So what did you realize that you have to slow down?
Yeah. Well, so when we initially did this, there is a session law provision that dictates that the PUC extend the existing rate, because that is in an order. And so it originally was supposed to expire, I guess if we don't, so it was set to expire in October of 2024. So now it has been backed up until October 1 of 2026. So it would be good for you to change it here so that I don't forget again, since you're pushing it back to 2028.
So they're getting the same rate, but they're continuing to get the rate that they've gotten since 2012.
Yeah, and it's.
What is that rate, and is it higher than it should be? I mean, shouldn't the PUC determine what the rate is that they get?
Well, so a rate case would take them 9 to 12 months to do. And so the whole point of subsection K.
I know, but they just continue to get a rate that they should be getting for years.
So I'm not saying that could be, I'm sure that's, sure, okay, I'm not saying that, I'm saying, so. You could hear more from them on what that
We
is.
did ask the PUC to either come in or have written comments, and we did get an email back from Greg Faber saying that they supported the language, they had no other comments to submit in writing. So
Even the rate, did they make a comment on the rate change? And will they not come in and, I'd like to ask some questions.
okay, we can have a meeting tomorrow. See if they'll.
Yeah, I mean, I would like to ask them that question about the rate.
Yes.
Because we're just continuing, we've been continuing to give them the rate that was supposed to be a 10-year rate.
Yeah.
And now it's turning into a 14-year rate. And is it the rate that they should be getting? Is it unduly high and therefore impacting ratepayers for people? You know, these are Vermonters paying electric rates.
I think it's a good question. Yeah. Okay.
All I think I can speak to that is that for them to do a new rate case would take 9 to 12 months. And so that is why K, you know, you adopted K to have this series of requirements for Rite Aid to do. And then after they did them, the PMC would evaluate based on the new changes that had happened, as well as, you know.
I
other
know, but
outside-
this whole construct was developed 4 years ago at a time when they were asking once and now they've asked 3 or 4 times. So they continue to keep that, and I just wanna know what that rate is compared to what the rate everybody else is getting. Like, is it unduly high? And maybe we do a percentage of the rate that they're getting. And then instead of a rate case, an entire rate case, we've already made the call for 4 years that they get to keep this rate. So we could make the call that they get to a different rate.
We can have that conversation. I think it would be interesting to see what the PUC says about. I wonder if it would be a little bit interfering on their work, but we can ask.
This was interfering on their work.
That's
We were
true,
saying,
yeah.
let's extend this rate without a rate case.
Yeah.
We've done it for 4 years now. So I mean, I just wanna ask the PUC these questions. And maybe they'll have answers that are fine, but
Let's find
it
out.
seems like a continuation of a deal that we were giving that has now changed multiple times.
Mhm. Yeah, sounds good. Any other thoughts, questions about this in particular? It's a good call. And anything else to lead us through?
That's all that's in the graduation method.
Okay. Great. Okay, so, think we should, wait to vote this out. We'll see if we can get a great favor in here tomorrow, and, we'll go from there. Which is totally fine with me.
Can I make a suggestion on just the bill reporter situation?
For 319.
Well, yeah, so we have these two big bills that have a lot of things.
Mhm.
What I was gonna suggest is maybe Senator Williams and I do the fish and wildlife bill.
Oh.
And the three of you do miscellaneous AR. And that splits it out with the whole committee, and then we don't have the, so it's so
Sure.
Senator Williams and I will figure out which sections we wanna do.
That sounds good to me, and yes, that works, for, just so you know, I mean, for 319, I was just planning on doing the whole thing.
I'm sorry.
No.
I was just thinking it was also a really big bill.
Yeah. I bet, I mean, if I can potentially, tap either, Senator Bogarts or Beck, if there's parts that I'm like, this is a lot, can you take like this one section or something?
I think that Senator Bonner really wants to do the paint section.
I'm not.
Section.
So we'll leave Fish and Wildlife to you all, if
Is
that's.
that okay?
Oh, yeah.
I just was trying to think of how to be up.
No, I think that's fair, and, we'll go from there. The thing is, I feel like I've got a lot of the background on EPRs and, I'm a super fund and flood safety act, I mean, if there was flood safety act stuff, Senator Bogarts that you wanted to do, like, there's a lot of dates being pushed back there. We can figure it out.
Just look at it.
See my home.
Okay, okay, that sounds fine. Yeah. Okay. That sounds good to me. Okay, thank you. So this one's to be continued. And then moving on, looking at, since you are here, actually, how late can you be here?
I'm fine.
You're fine, okay, so we could take a 5-minute break, because we are running quite a bit ahead at this point, so let's take a 10-minute break. And we'll come back.
Okay. I don't know what version you have, but this is what I.
Okay.
Okay. Yeah, 12 pictures.
Oh, yeah.
We have
It's just
invited,
like,
Senator Robert in to scale, 10:30.
that's okay, it's almost 7:30. Okay. Oh, we're unmuted, okay. Amazing, all right, so this is Senate Natural Resources and Energy coming back from a break. And we have possession of 479. And would love to walk through with our legislative council, particularly the part about the appeals that is different from what we had talked about, but I'm glad that we have that background, so. Yes.
So, Plan Economic Development passed out of their committee draft 5.1 at H 479, this is the housing bill. And so the sections that I drafted start with section 14, which is at the bottom of page 26. So I did sections 14, 15, 16, 17. Those are all related to municipal permits. And then section 18 is the language regarding the Land Use Review Board appeals study, and that hasn't changed from what you passed previously. That is also part of my sort of sections. So, page 26 into page 27. So, do you want to start with Senator Robinson? Or is it good? Let's through something. I don't have it. I do not send it to you.
Would you like to go now, or do you want to wait? We want to make space for you if you have.
Well, the,
Up to you.
my technical challenge, Senator Pedro, and still for the record, is that yesterday I printed the section by sections and side by sides to, the copy room, and it's probably sitting there in a pile, and the copy room is closed, so.
Oh, really?
That's, but you think it's done?
It was done yesterday
Okay.
evening, I had just left,
I can get in.
so if there's a thing that says my name on it or.
Yeah.
We can go through
So,
the walkthrough with Ellen, okay,
Yeah,
so let's continue.
Sure, so, currently for municipal permits, there is a definition of who is allowed to appeal them, who has standing. So currently in statute, that is defined as an interested person. The proposal that came over from the House, in which the Senate then modified, is, an interested person has 5 different categories, people under it. The proposal from the Senate committee is to remove one of those categories, that any 20 persons, and add a new category of aggrieved persons. So I'm at the bottom of page 26 and 27, this is section 14, and so I'll remind you that sections 14, 15, and 16 all work together. The language is spread across 3 sections, but it needs to be read together. So first, section 14 is amending 10 VSA 8502, which is the definition section for the environmental court, and the definition that they look at it, who gets to appeal. So on page 27, the definition of person aggrieved is being amended. So a person aggrieved is a person who alleges an injury to a particularized interest. So that's a phrase that's said a lot, particularized interest. Protected by the provision of law listed in section 8503 of this title. So 8503 is a list of statutes that the environmental court has jurisdiction over. It does include chapter 117 of title 24, the municipal zoning chapter. And so a particularized interest protected by the provisions of law attributable to an act or decision of a district coordinator or district commission. So that's for Act 250 decisions. The secretary of natural resources, so decisions on A&R permits. And it's adding an appropriate municipal panel, which is the body that makes decision on municipal permits. Or the environmental division that can be redressed by the environmental commission. Language has been added here that also says, for the purposes of appeals pursuant to 24 VSA chapter 117, the injury alleged shall be to a particularized interest protected by 24 VSA 4302C. So this is was suggested to clarify. What the particularized interests are for that chapter. Chapter 117 is 200 pages. And so I think it is unlike Act 250 appeals and ANR permit appeals, which are types of appeals that have very specifically defined criteria. Whereas for municipal zoning, there's a sort of broad array of things that the municipality can regulate through their zoning. And so this was my suggestion for a more specific citation of what the interests of that chapter are. 4302 is the purposes and goals of the chapter, and 4202C is actually a very long list of different things that the zoning and regional and municipal planning should address. And so I can walk you through that statute if you'd like. I think potentially there are other things you could cite to, but it is more specific than just saying anything within chapter 117, so I thought it would be clarifying.
And just to be clear, this also does not include, like if I recall, D included character of the area. And so that's not including, right, we're intentionally not including character of the area here.
This has nothing to do with that, but we can talk about that.
Okay, I'm just remembering there was something.
I was gonna
Yeah, go ahead.
suggest,
Yeah.
the only reason I wanted the section by section is because I couldn't remember exactly which sections are your jurisdiction and it's on paper.
Yeah.
But I could come up with Ellen, if it's easier for the committee to hear as you go
As we
through
go.
sections.
Sure.
This is why we did this.
Yeah.
And
Yeah, that would
like
be,
that.
that would be
If
fantastic.
Ellen's okay with that.
And that's. Okay, great. So, welcome.
Thank you.
Yeah.
Senator Keisha Robinson Steele, recorder of H479. So I don't know if this is the first section you're looking at, is the brief, okay. I think it would be fair to say that this is a pretty tortured section. We spent a lot of time on this, and these were the factors we were considering. We had done extensive work, as the chair mentioned and remembers, on increasing the threshold for municipal appeals last year. So such that more people had to have participated in the process and then take part in the appeal from 10 to 20 and up from 1 and 5 in past years. And that they not be able to appeal based on the character of the area. That was really important to the committee from a de jure discriminatory perspective. I don't know if it's de facto or I think it's de jure, like not unintentional discrimination could occur, or intentional when you're talking about, this doesn't fit the character of the area. So I came in before and I had those 3 permit, like 4 permit columns if you count the federal government, but in the state you have 3 permit columns. And what I think was really critical for us to understand in this discussion is that there are opportunities in the 2 other permit processes to be aggrieved and be from anywhere in the country, let's say. So you can claim you're aggrieved, even if it's you're a California environmental lawyer, if you're focused on, a wetlands permit, or if you're focused on the Act 250 overall impact. Municipal permits, we came to feel very strongly should remain about the geographic proximity that the person has to the project. Right now, I think it's important you leave adjoiners and abutters because they might be in the town over, you might be impacting someone who doesn't otherwise have standing in your municipality. But besides adjoiners, a municipal permit, especially when you're talking about small towns without a lot of staff, should not be having to field someone's claim that they are aggrieved from well outside of the bounds of their geographic region. So then
I was willing to. I won't say but I think the committee shifted from its willingness to look at aggrieved when you're talking about someone who already has another type of standing. And in that case, I'm enthusiastic, or our committee was happy to remove the 20-person standard. Because yes, you will hear that, hey, 20 odd people, like, what does that mean? We're just increasing the number every time. It's not a great standard, but I don't know that we hit the mark by adding aggrieved to the other elements of standing. I think we could always do more work on the any 20 people and make sure that we really have a critical sense of why they have a particularized physical or environmental impact, that they are not using things like character of the area. But we wrote that section after careful discussion with local government, because local government is the ones who came to us and said, we would really like to not just have anyone in town appeal our permits. These are generally the 5 to 50 unit projects that we need in our core growth areas or downtowns. They're walkable, and it is a frustration of ours that almost anyone in the town can walk in, any 5 people, let's say, and appeal, but we don't want to take away the local community's right to be heard. So we had lots of numbers that we can continue to discuss forever, but we landed at the time on 20. They had to have participated in a town planning process first. Should we talk at some point about a town plan that specifically designates an area for housing, for growth, for multifamily, dense housing, and then someone still appeals? We are continually trying to get at that, because that does feel unfair in the community, and it can add millions of dollars to the cost of the project. And the last witness that we heard from, I think that's very helpful in talking about why you should keep the geographic proximity, even if they didn't have a good experience with appeals, is Kathy Byer and a project in Putney that is 25 units, because it now will happen, but it went to the Supreme Court twice because of an adjoining landowner, and it cost, I think, $3 million extra dollars, and this is 25 units. And that person is in no way responsible for the additional $100,000+ per unit.
It's so hard.
So hard. So are we in love with the aggrieved thing in the municipal appeals? I think our committee just spent a lot of time on it and had to let it go with this.
It's good to know.
Yeah.
That context.
Yes.
Yeah. Okay. Any questions about that for Senator Romney? Yes, go ahead.
I don't know who these questions are.
Or could be either.
Cause
Yeah.
I think we also probably need to continue to walk through.
We walk through and then have a conversation.
We could, I mean, if there's anything
Fine.
that questions about what Senator Romney just talked through.
No,
because otherwise we
it's not
can.
the language itself.
Yeah, so let's continue to walk through the language and we can ask questions as we go.
Is it about language just walk through though? You wanna talk about that?
Okay, yeah, well, I mean, I was just thinking about the testimony we got from Judge Snre
Mhm.
about this particular, about 4302C. Because it's a long list, and
He's coming in.
you know, he was concerned that there's case law on the particular process right now that'll have to be new case law built. It's not it's more specific than just saying the entire chapter, but it's still a pretty long list that is easily interpreted.
Just so you know, we will have Judge Zoney in again today.
Okay.
To talk about this new language.
Oh, this is the same language from the
It's
last.
different from what we walked through.
Oh, it is.
The specific sentence isn't, but
Yeah.
Sorry. There's a part of it.
He had concerns with this list, and that it's pretty long and not super specific.
It is long, it's true.
Is that a question?
I don't know the question, because you said that you put it in there to make it more narrow and. There are continued, at least concerns from him about it not being narrow enough or detailed enough, and it'll take a long time for the court to sort of. Rework the case law on what this means, and is that a problem?
So chapter 117 itself is 260 pages.
Right, no, I.
And otherwise in the chapter, there isn't a defined list of things. Like Act 250 has, where that defined the criteria. The 10 criteria and all the sub criteria. Or like an A&R permit that is protecting wastewater. Which is more defined and very discreet, so. If someone else thinks they have a different list
I
that
don't.
reflects
I'm just
what
wanted to-
chapter 117 is attempting to do. I don't. You could take this out. You could take this out, you could propose a different statute. I was asked to look for a statute, this is what I proposed, Judge Zone hasn't actually proposed anything else. If you want to just take out the whole sentence, you can. And then it would be very unclear.
Right, no, I mean, I appreciate that you were trying to make it clear, I totally appreciate that, I was,
So
I don't understand.
anytime you make a change to a statute that is new, there may be case law to determine the specific contours of it, that is what lawyers do. However, in this case, the person aggrieved standard has a lot of case law already. And so what is new is that it will be applying it to the situations under chapter 117. And so where will the plaintiffs in that case or the lawyers for them look to? They'll look to the whole chapter unless you include something more specific. So you do not have to include this.
What I will say this, like, I definitely please hear from Judge Sone and take very seriously that he believes. Any changes in the section open up new opportunities for people to test out the case law. At the same time, the best thing our committee could think of was, I believe there's a sentence in there that says there is no reopening of cases before the effective date essentially of this bill, which I was very concerned about because a lot of projects, they will have made peace with surrounding neighbors and community members based on a certain set of factors. And then if we said, well, they figured out a new way to feel aggrieved, that would be very concerning. So I don't know if it's perfect language, but we essentially tried to create no opportunity to look back at projects that have already received some type of approval.
Okay, great, thank you for Steve.
So section 15 then uses the new definition of a person aggrieved. So for 10 VSA 8504, this are the process for permit for appeals to the environmental division. So for planning and zoning chapter appeals within 30 days following the date of the active decision, an interested person as defined in 4465 or a person aggrieved owning or occupying property in the immediate neighborhood of a property that is the subject of the decision or act. Who has participated as defined in 4471 may appeal. So this is different than the language I brought to you a few weeks ago. And now instead of just a person aggrieved, it says a person aggrieved owning or occupying property in the immediate neighborhood.
And is immediate neighborhood, is there either case law about that particular phrase, or is that defined somewhere?
So currently in the existing definition of interested person, category number 3 is a person owning or occupying property in the immediate neighborhood. And so there is case law that has looked at how far away or what the proximity is for someone to be in that area. It does depend because not all neighborhoods are defined more clearly than others, like in a downtown area, knowing where the neighborhood is different scale from a more rural area. I did see case law where the court found a half mile away because that was the closest neighbor could be considered the immediate neighborhood because the houses were more spaced apart. There it becomes a little more unclear because is that really so generally walkable, but I don't think the court has put an exact number on it beyond saying half a mile away, closest neighbor is.
Great, thank you.
I'm gonna just flag something here, so the committee came up with this on the last day. This is where we get into like the complicated legal scheme at issue here, so there's this concept of standing under the law, there's constitutional standing. Who is allowed to seek an appeal from the court has been defined as the US Supreme Court as needing to have an injury that is able to be redressed by the court. The court has also said that legislatures, that is the most basic requirement of standing and that you can't get rid of that requirement. But the court has said that you could expand, the legislature has the authority to expand and define other classes of standing, which is how you ended up with the 5 categories for municipal permits. What's happening in number 15, in section 15 with this, a person aggrieved with a locational requirement. I have not done analysis to see if there have been other times that this type of standing has been defined. I think there is some risk that this is changing what is underlying constitutional requirement for standing. Under constitutional requirement for standing does not have a locational requirement, and this is adding one. So I think there's a risk there that this could be considered non-constitutional by the court, but I haven't looked into that in depth other than the existing research I had been doing to define a constitutional category for standing in this context. So raising that as a flag, but it is something that the committee obviously was very interested in, was location.
If I haven't made it clear, we took a proposal from the House and tried to re-narrow it. We were very concerned about the broadening that you will hear from Judge Zoe. And we have a committee who's very ethical and tries to meet people halfway. We have already had a discussion in committee that this whole thing may not survive. So I just want to let you all know before you spend too long trying to be kind to our committee, and maybe spend too much time on that I don't think the committee believes strongly that this is ready for prime time.
That's good to know. And then, just so I'm clear, so Ellen, the part that you're wondering is, has the unconstitutionality question mark. Is that this line at the bottom of page 27 still?
Yeah.
Yeah, okay. That's what I thought. I just want to make sure that I was in the same place. So, okay.
So then on page 28, line 6, language is added that an aggrieved person shall not appeal an active decision on a permit application filed on or before June 30th, 2025. So, under the construction of statutes, under the Vermont statutes generally, legislation is prospective and only applies to future projects unless the statute specifically defines that it is to apply retroactively. So this new scheme of using the interested person standard would only apply to future cases that are brought to the court in the future. However, this is language that is a slight clarification that there may be permit applications at the municipal level already underway, and depending how long that takes, this statute could already be in effect, and that this new standard is not to apply to any applications that have not been approved yet.
That makes sense.
On page 29, this is language that you have seen before. It hasn't changed. This is just asking the court to prioritize housing development appeals over other cases unless they have cases of greater importance.
And this hasn't changed from what we looked at previously. Okay,
Correct.
yes.
So then section 16 has on page 30 into 31 have changes that the committee made that you have not seen yet. So the committee has so there are these 5 categories of interested persons. They're used for both appeals of the town planning bylaws as well as the permit. The language on page 32 says that category 4 is not going to be used for permit decisions, just for bylaw decisions. So if any 20 persons in the town want to get together and appeal the bylaws that they approve, they can still use that process. But subsection 3 is going to remain for both bylaws and the permitting process, and so Senate Economic Development has made amendments there. So this is again, who can appeal an interested person? It's a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter, who can demonstrate a particularized physical or environmental injury to the person's interest under criteria reviewed, and who alleges that the decision or act will not be in accordance with policies, principles, and things. So, this is language sort of merging the two types of standards that we were using in the prior section. So there's been this interested person who had a physical or environmental impact to their interest. This is different from the aggrieved person standard, which requires a particularized an injury to a particularized interest. And so this is merging them. So who can demonstrate a particularized physical or environmental injury to a person's interest. And again, they have to live in the immediate neighborhood.
So, how are we defining particularized physical or environmental injury? I guess the use of the word particularized, because it sounds sort of like the particularized interest list that we referenced previously. Which was, tied to 4302C, that big long list. And so are we saying that a particularized physical or environmental injury is like somehow referencing that list and also further narrowing to say just the things on that list that have to do with physical or environmental injury?
No.
Oh, okay.
No, I'm not sure how this language would work.
Okay.
So, the existing analysis is whether or not there's a physical or environmental impact, which I think some people believe is a sort of weaker, lesser standard than a particularized injury. Generally, under other case law, an injury to a particularized interest has been fleshed out to say, it has to be particular to that person. And it cannot be a generalized interest shared by the members of the public. I think to some extent that's already done for subsection 3. Impact is not as strong as injury. I think injury is slightly stronger, but.
Right, so impact could be, this is going to improve my view shed and I hate that, like this, so, right, so we're saying that it's a negative impact specifically by it being injury, and the particularized part there is just to say that this is specific to the person rather than the general public.
Yeah.
Okay, thank you.
So we did, if any of this survived, we did feel good about moving from impact to injury to be a little bit more specific about what is
Yeah, that makes sense.
actually a particular injury to your front.
Yeah.
So the rest of the language, I think you have already seen, so at the top of page 32, this is what I just said, for purposes of an appeal of an active decision of appropriate municipal panel for subchapters 10 and 11, which relate to permits and permit appeals, interested person shall not include subdivision 4. So this is sort of this is the separation of 4 can appeal permit decisions. And then section 17 has not changed. This is saying that bylaw amendments that are required to comply with the amendments to this chapter, no hearing is required to be held. There hasn't been that much testimony on that, but I think you could have testimony on this. I do have, initial concern that because participation is required at a hearing, if you're eliminating the having of that hearing, is that putting in, that ability at risk? I think the court would find if there was no hearing that someone could potentially still appeal if it was manifest injustice. Also, not all of the amendments you make to the chapters are very specific. They need to have you know, the town actually sit down and figure out how and where they apply in the town, so there is some bylaw amendments that are made that you, could make to bylaws that would be very sort of direct and, pointed, whereas others are sort of more sweeping, so I think this is pretty broad authority, but
It's good.
Can I ask the Senate, why was this included?
Yeah, I just wanted to underscore Ellen's assessment that we didn't take a significant enough amount of testimony on this. I think we spent so much time on the other one
Yeah.
that even I looked at that and thought, oh, like, I don't remember a robust discussion on that. And I think it could have.
You as in there, okay.
so, yeah, so I think BLCT was interested in this, municipalities are interested in this, it will save them time and also, it can be frustrating that especially when the legislature makes an amendment to the chapter that the town is required to comply with.
We do hear
And then they have to have a series of hearings on it where there's debate, but the town is, you know, to some extent required to do what's in the statute. It can be frustrating, but
It's like to what end? Because they don't have a choice. They have to adopt it. Mhm.
It's a good point.
Yeah.
so that's the end of the municipal appeals. Section 18 is the, moving up the date for the appeal study from the land use review board to November 15, 2025.
I think you should feel free to, you know, look at that as well. I think there's a real difficult balance here between wanting to make their work actionable before December 10th. As our filing request deadline. I mean, we could still put in a request and not have specific language baked. Because November 15th is just a lot sooner, and I feel like we keep adding to their charge, like either in actual words on the page or just saying like, oh, they'll take care of that. It was helpful to hear that John is on their appeals, like, working group. But it's a large group, and just asking people to finalize things before November 15th could be an issue, so I think we had this conversation and then had a huge appeals conversation, and it didn't feel clear to me that we reconciled how much we are asking them to do and kind of pushing municipal appeals back fully into the conversation. And then look back at that date and say, is that workable? Like, I don't think after that, LERB came in and said, oh yeah, that works for us. I don't know if John.
And I did, John Groban, you know, so when I get to testify, we had another 4-hour meeting on Monday, what's today, Wednesday? And we talked about this, so I can convey what the letter said, so they could.
So maybe go with that. I think we would listen to that as well as new information.
Super. All right, thank you so much.
Then, I just want to note, you know, while I'm here, that it's maybe more likely than not that this will be the vehicle for the housing discussion at this point, given its momentum toward the floor, as opposed to S-127. So, just making a note of that, and I think it's worth getting the section by section summary, because there's a lot of other pieces that indirectly, you know, things like land banks, where we know we need to start looking at lighted areas, or places where we need to have water, sewer infrastructure for FEMA trailers, et cetera. This has been our interest in keeping the land bank conversation alive. It's very interested, very particularly, I would say the pieces on immigration status and fair housing are really hard fought and have a lot to do with those who work closest to the land, having a safe and adequate place to live and to continue our working lands industries in a big way. And it has been a long time that this request has been in the works, and I was very heartened, that we did have a 4-1 vote, including Senator Brock, to advance that, because Senator Brock has always had concerns about any type of fraud or, anything about credit, reporting. If anybody wants to hear, I'm sure it will happen on the floor, but we can talk a lot about, how a landlord does not need a social security number to run a credit check. It is certainly helpful if they don't, if they have a very common name, but they have other ways of verifying that person's identity. And, we think that's a really important proposal, especially in this moment. So we hope, you can help us advance this whole package. I will say a majority of our committee have been looking forward to some other provisions coming to us from the House that didn't end up making it because of the same jurisdictional questions that tend to mire us, regardless, and that was the opt-out for tier 1B, instead of the opt-in. I think Senator Baumgart remembers that as Representative Baumgart, that was something that was painful for the Senate to lose, because those are the areas where we're probably going to get the most smart growth is 1B. We're gonna build maybe some tall buildings in 1A. And we're excited about that, but we're gonna get a lot of what is Vermont size and what people need to have walkable, transportation rich communities in 1B. And we had heard that Representative Mahali really wanted to take on constructed wetlands and wetlands permits for areas that have become a wetland after other development has occurred and the buffers there. And he had planned to do that, and then certainly did not have jurisdictional authority to do that. This is the committee of jurisdiction for A&R permits. When you look at those 3 columns of permits we have control over, I would certainly credit Senator Baumgart. We looked at municipal permits, we looked at Act 250, an A&R permit, and a decision on whether or not to issue it at all could completely stop a project dead in its tracks. So, I don't want to lobby you further than that. And it may not make it this year, but I really hope we can make sure A&R permits get their full opportunity for discussion when we talk about infrastructure, which I think we all agree is the best way to keep the lake clean, is the best way to, keep our systems operating and our economy thriving. We are, I believe, going to start to see more appeals to the infrastructure projects that we fund. We heard the preview of that with Montgomery, that has been working for over a decade to put the funding together for a wastewater upgrade. And now that wastewater upgrade itself is being appealed.
Can I ask a
Yes,
question?
go ahead.
Yeah.
And then we probably need to move on.
Yeah,
The version of the CHIP program that's in here, is this, that's the version that the House is currently considering, or is the version that we passed?
Yes.
Okay.
Yes. So I guess in that vein overall, I would say, please, while I may have gave you the impression that, some of these sections could die here, they're always alive in conference committee and will need your good brains, depending on who ends up in the conference committee to be discussing this aggrieved person standard and things like that were important from the House perspective. So, I'm really glad Judge Somay is here, I'll say that.
Thank you so much.
Thank you for coming.
Okay, and so. Mr. Goodman, would you be okay if Judge Zonay?
Sure.
Okay, thank you. Okay. Are you okay to go now? Okay, all right, welcome.
Good morning, Tom Zonay, Chief Superior Judge.
So if you have something you wanna just jump into,
I have
that's
some thoughts,
fine.
but I'm wondering if maybe your questions will bring out everything. I
Yeah.
would start off with my normal, this is a policy. I reviewed the most recent, what I think is the most recent version that came out of economic development. And I just want to be very clear that whatever policy you enact, we will go forward on. But this policy certainly appears as though it still broadens the scope of people who would have the ability to have standing to pursue appeals. And thereby, with some of the new language, and the court would have to assess the parameters of it, in terms of what does the legislation mean. That takes time. And that, again, that is a function of new legislation, but putting it into practice is gonna be something that takes time. So if there's an expectation that this would speed the process up, I don't think that is what will happen.
Mhm. Thank you, and there had a specific question that I had for you, and we'll have for, I think, one of our witnesses. There was a question about the constitutionality of. It's page 27, the changes that are in paragraph. It's section 15B1, line 17 through 21, but this addition of the immediate neighborhood to who can be have standing. I don't know if you have any comments on that. No.
The moment you say the word question, the phrase questions about constitutionality, I cannot really respond to
Oh, I
that
see.
because it
Okay.
would provide an advisory opinion, because those are precisely the types of questions the courts would have to assess. So I can't weigh in on that.
That makes sense. Thank you, I appreciate that. And any other, particularly of any of the new aspects of this, anything you comment?
Well, I previously touched on where it talks about protected by, in section 14. The last line that's been added talks about for purposes of appeals pursuant to, the injury alleged shall be a particularized interest protected by 24 VSA 4302. And again, 4302C, I said this when I was here last time, is a broad policy. It talks about broad policy goals of zoning. They're non-regulatory provisions that do not necessarily protect individual interests. But also, they may not be relevant to any of the municipality's specific zoning regulations that are applicable in the appeal. And so it's unclear how the court would apply that when it comes to standing that provision. And that's one of the provisions that I think would lead to additional litigation. People would say, well, no, I do fit under this, and here's why. And someone else may say no, and then the court would have to assess what are the limits of it and what does it look like.
Yes, ma'am.
So I remember that testimony from before, and I asked Alan Tchaikovsky this question too, and I think that this, my understanding is that this adding this language was an attempt to narrow it, so it's not just all of chapter 24 and or title 24, and then it, because there's standards for Act 250 appeals, this is an attempt to have more a list of potential standards for zoning appeals. So if we took this language out, wouldn't it just broaden it to the entire title in a way that might be difficult to, even more difficult for the courts to discern?
The criteria, the goal of the 4302C are pretty broad. And so what it seems to be is an attempt to now take person aggrieved under the section 8502 definitions and have that start working in the municipal appeals under 4465 and working there.
Right.
Because there's a perceived view that the 4465 B3 that talks about immediate owning or occupying property in the immediate neighborhood and physical or environmental impact. There's a perception that that is not limiting enough.
Mhm.
If you didn't do anything to person aggrieved and left it alone,
That's the way it is under 4465. That's narrow. And you're also capturing the fact that someone has to have a particularized injury under the cases that I previously sent along. So I understand that the problem here that you're trying to address, which is, okay, if we bring a person to grief because you're adding language about an appropriate municipal panel. The issue arises when you bring it into the appropriate municipal panel here. If you take that language out and you got rid of it, you don't have the problem because you already have the limiting language in 4465.
But I wonder if this was included, and I don't know, I'm speculating because I'm not on that committee, but if whether this addition to persons aggrieved was. They were both trying to narrow the appeals and also if someone really does have, if somebody really is injured by a municipal zoning to still allow them under a different standard to be able to appeal.
Well, if you go to section 15,
Yeah.
and I apologize, I'm going out of the version from the Senate calendar. That's the one I got. It says within 30, on subsection B, within 30 days following the date of decision, an interested person as defined in 24 VSA 4465. So we know that person owns or occupies property in the immediate neighborhood, and they allege a physical or environmental impact based upon the criteria. The zoning regs. But what has been added, or it says, or a person agreed owning or occupying property in the immediate neighborhood of a property that's the subject of a decision or act. What does that not include? It does not include the limiting language of physical or environmental that the prior clause includes.
Right.
Person, and remember, if you look at the Capitol Plaza decision, as that explains. If you are someone who meets the criteria of the interested person under section B3, that generally will give you the injury that is necessary for what we'll call constitutional standing. And I point that out because if the idea of adding person agreed is to put in this constitutional standing, and it goes forward. If you are someone who's an interested person, you would also be someone who's a person aggrieved. And if person aggrieved doesn't require you to have to show that it's a physical or environmental impact, but all these other impacts, you basically have just removed them from 4465B3. And so even though you're keeping both, it appears as though what's really happening is that the person aggrieved is gonna overtake the interested person. Because as the courts have ruled, you still have to have an injury. And if you're an interested person, you're gonna have, is it gonna be a particularized interest that is protected? And so the aggrieved person standard is broader. And would seem to incorporate the interested person standard.
Okay.
And I also know that when it talks about person aggrieved, it indicates that the injury shall be to a particularized interest. However, when you look at 4465B3, it talks about a particularized physical or environmental injury to the interest. Is there intended in the legislation to be a difference? Interest and injury are oftentimes viewed functionally the same, but is the legislature choosing those two different phrases for different reasons? And these are the types of questions the courts would have to address.
Where's the second one you just?
In section 4465 B3.
Got it, okay.
That's the interested person.
That's correct. That's the interested person.
And do you have any thoughts on, because we do change it from I should say economic development, changed it from impact to injury. do you have any thoughts on that particular?
Whichever one you choose, just use it the same. In other words, make it consistent.
Just be consistent, okay.
Be consistent, although I would note that if you choose injury, at least under 8502 subsection 7, for person aggrieved, it would say the injury shall be to a particularized injury, so that probably wouldn't sound very good. So
Right.
whatever one you use, I think you just need, it would be helpful to be consistent.
Okay.
The other point that comes up is under the group of 20, unless I'm mistaken, under subsection C that's been added. It says under section 16, for purposes of an appeal of any act or decision by an appropriate municipal panel pursuant to subchapters 10 and 11, interested person shall not include subdivision B4 of this section. I stand to be corrected, but if I'm not mistaken, those are the only two subchapters where this provision could provide them the ability to appeal. So I'm getting a head shake, no. That, my understanding was that's the way it was. So.
Sorry, can you say where that reference is to?
The reference about, for purposes of an appeal of any act or decision by an appropriate municipal panel pursuant to subchapters 10 and 11.
Oh, I
The
see.
person shall not include,
Oh, I see.
that is where those appeals would go in the group of 20.
Mhm.
But I'm seeing out of my corner of my eye, Ledge Council may have another place where it goes.
You want me to?
Sure, if that's.
So-
okay.
The. LJ Council, legislative council, so. Interested persons have the ability to appeal decisions on municipal plans and municipal bylaws. Which are just the process for which is described in subchapter 6 and 7. And so only the permit process is described in subchapter 10 and 11.
That's correct, because those other appeals would be to the civil division,
For the bylaw.
of the bylaws, that's correct. They would not be to the environmental division.
Okay.
So if that's the case, you would agree, then I just, well, I won't question. But yeah, those appeals go to the civil division, they're not to the environmental division.
Okay.
And the only other thing I would, again, note. I said it once before, and I won't, unless you have any questions. The last section of section 15 about except for cases the court considers of greater importance.
Mhm. Yeah, great,
I won't repeat it, but.
Yep. Thank you. We'll recall that assessment, appreciate
If
that.
that can come out, that would be helpful, but that should be.
Okay. Okay, thanks so much.
Thank you.
Any other questions?
Have a great day. And if you want to chat at some point about that other matter,
Great, yes.
please let me
I
know.
probably should stay and talk about this, but yes,
That's
I
fine,
would
but
like.
go ahead.
Thank you.
Thank you.
Okay,
Take care.
so we'll go to Mr. Groveman, welcome.
Thank you. No, it's the end of the session when I can't bear to put on my jacket. Don't
Okay.
indulge me, getting warm out there.
No problem.
So for the record, John Groban, the policy and water program director for Vermont Natural Resources Council. And you weren't in the room when I testified last time, so just for like super brief background, I'm also an attorney. I've been involved in dozens of appeals, A&R appeals, F-250 appeals. Zoning appeals, I've been the chair of my TRB for years, and I was actually the director of what was the Water Resources Board when we moved all the appeals to court, created the person aggrieved standard for Act 250 and A&R permits. So I've been around these issues for a really long time. I guess, where I like to start is obviously this is really complicated. Just listening to this conversation, and I tracked it and testified a number of times in Senate Economic Development. I'm glad to hear Senator Ron Manziel flag that maybe this isn't ready for prime time, because it is super confusing. And I guess I'd like to start with, so I'm also, VRC was obviously very involved with Act 181 and every aspect of it, including the appeals issues and how to have more efficient and effective appeals. Senator Bondar's was a major, as a House member, a major, sort of player in crafting all of it, and including the appeals section. And we couldn't agree on how to make appeals more effective, how to make a stronger Act 250 program while making appeals more effective. So we did charge the new land use review board with the study. I am on the study group, along with like 34 other people. But as scary as that sounds, and as you know, and I was really, when I looked at the list, I was like, how are we gonna do this, you know? But I've had two meetings and they've gone pretty well, and Mr. Weiss is also part of the group and he can talk about it from his perspective, but you know, it's been good because these issues are so complicated. And we are talking about zoning appeals and A&R appeals and activity appeals, because you can't talk about them separately because they all end up in the court. The court's workload, if the concern is housing, it's affected more by municipal appeals. We've looked at a lot of data as part of the appeal study. They're like something like 60 to 70 zoning appeals every year. There's 5 to 10 Act 250 appeals. There's 5 to 10 A&R permit appeals. So clearly zoning is the workload. Zoning is affecting the court's docket. You know, we have 2 judges and limited staff. So we're talking about all the appeals together. We're talking about what kind of system could be more efficient. We're talking about how to, in particular with housing appeals, which is the housing bill. So that's been the focus of this. And one of the things we talked about in our last meeting, and I actually brought up to the Senate Economic Development, and with my fleet of the committee, if they're wrestling with this person agree standard and all the issues that you've heard about, was that really, and I have done some research on the constitutional, so I'm happy to talk about that. But what I've seen is what other states have done, people don't go to limiting appeals to try to move housing projects along. They try to basically reduce permits that are needed for housing projects and issues in permits that housing projects need. Because I do think that states realize that, and Ellen flagged this issue, and there's not a lot of case law because states haven't gone so far as to limiting appeal beyond what the Constitution requires, and instead they'll do things like, if you, for an accessory dwelling unit, basically it's a right to have that in a particular zoning district, and if you meet the setbacks and you have water and sewer, you get a permit for that, and then, so there's nothing to appeal, right? What's to appeal? You know, you can measure the setback with you just go out and walk there, 25 feet, if it's 50 feet, whether you have water or sewer is clear. The appeal question becomes when you layer on parking requirements and you're looking at traffic impacts or character of the area, as the chair mentioned earlier. And you can do that for multifamily housing, you can do that for affordable housing. And that's what states have done, not limiting appeal rights, because you do bump up against the issue that property rights cuts both ways, right? So you own a piece of property, and if the government, including local government, says you need a permit to develop your property, that also affects other people, how you develop the property. And not only does the landowner have a property right to pursue that permit, but other property owners that have a particularized interest, that have a particular injury related to that activity, if it could be redressed by a court or entitled to due process under the Constitution, under the 14th Amendment of the United States Constitution, which says you can't deprive someone of life, liberty, or property without due process. And that due process, and you could certainly have a debate about how much process you get. And I know this is a super different issue than what's happening with the terrible immigration issues in our country right now and people being deprived of due process, but it's the same exact provisions of the Constitution. In that case, it's life, liberty, and property. So in those cases, it's liberty and life. But this is property, but it's the same provision. You're entitled to some process, which is why I say the way I think states have done it, and we've done it a little bit in the Home Act. Not the housing bill last year, but the one before, by having the by right provisions, by saying limiting parking requirements, right? By saying that there's a right to build certain, height of building. We've taken those issues off the table. I think that's the way to limit appeals. And I think the LURB study group is looking at when you do have an appeal, how do we make sure that that appeal is handled in an efficient and effective manner that's good for the Act 50 program is good for A&R permitting, and it's good for local zoning permits. I think what we have here, I think what the committee did in H 479 is really confused the matter. I think they've narrowed who can appeal, so you have to live in the immediate neighborhood. Ellen, I think I correctly said that has been interpreted as walkable. Here's my, and here's my example, like of an issue, and whether I'm right about this is unconstitutional or not, it's gonna get litigated, it's gonna be argued. So what if I had a client, there's a quarry in a town, and the quarry's on 8 acres. It's a town with zoning and subdivision regulations, so you don't need an Act 50 permit, because you'd have to be over 10 acres to need an Act 50 permit. And so 8 acre quarry, there's a road from the quarry that kind of goes out to the main road, could be Route 2, could be Route 7, pick your state highway, right? I live 7 miles from the quarry, but I'm on that road. And there are 50 trucks a day with loads from the quarry rumbling by my house 7 miles away.
And it's a dirt road.
And it's a dirt road, and then it goes out onto Route 7, Route 2, whatever. Under this statute, I'm not in the immediate neighborhood. I can't address concerns, impacts to my property, I don't get any due process. If the government permits this activity, I don't get to have redress of those actions, and that's not a housing project, that's an industrial project. And this didn't get discussed in Senate Economic Development, so I think what they've done is really problematic from a legal standpoint. Whether, you know, those legal issues will address. If I had someone came to me and I said, well, you know, you have a right to try to, you know, address those impacts to your property. We're gonna have to probably argue about this new provision in the statute that the legislature put in that seems to limit who gets due process, but we'll raise the argument. That's gonna slow things down. It has nothing to do with housing. And I can give you other commercial and industrial examples, but I just think this goes way too far, it creates a lot of confusion, and I would go back to saying, I'd rather have the LURB do its work. If we're going to create, I do think there's merit, which is why VNRC supported in the House, the person agrees standard, the particularized interest standard, but is constitutional zoning. Because that's the Act 250 standard, that's the A&R permanent appeal standard. I think there's value in having a uniform, consistent standard across all permitting. But clearly, how to draft that has become a question, and there have been good questions raised about how to draft that for zoning. The zoning statutes are different than the A&R and Act 250 statutes. So I would rather just take it all out and just let the LURB stay with the status quo and let the LURB do its work and make a recommendation rather than create this sort of confusion, which will end litigation and it won't make anything more efficient and effective. I do want to say, and Senator Hardy didn't hear this last time, and just to further show that these issues are complicated and, you know, this is not agreement on what the law is now. So, you know, Judge Zone, and I've heard him testify in the House and in Senate Economic Development. There's just not agreement that the standard now is. So we have the categories you heard about who could appeal a zoning permit. 20 people can sign a petition. You're in a butter. You're in the immediate neighborhood right now. I don't know what the fourth category is, but I can think of those three.
State agency.
Okay.
That's good.
Yeah, but those are the three main ones that I can think of right now. And, you know, there is the Capitol Plaza decision, which the chair is very familiar with, where the court said that, you know, in addition to being, it was 10 people then signing a petition, those people all have to have standing, and there was some interpretation that meant that this, unlike the Constitution, which says one person has standing, so my quarry example, that person doesn't have to find 19 other people. Under the Constitution, they have that right. We have this environmental court decision, which I think is up for interpretation, which some have interpreted as like we've said, you know, you have to have not just one person, but 20. I want to read, I did talk to, and you have an email from Jim Dumont, who was the lawyer on that case. And I just want to, I'm not saying he's right, but just like, this is going to get litigated, this is not clear. And I do think that the LURB study group needs to clear this up. So I'll just read what Jim wrote on this issue, just so you have like different points of view on this. So Jim writes, I understand the one proposal being considered is keeping the 20-person appeal route, but restricting the 20-person petition route to persons, each of whom can meet the constitutional minimum for standing, injury, in fact, really person aggrieved. This is based on representations made that this is already the law. In my opinion, it is not. There's one environmental division ruling that held that all 10, at the time it was 10, not 20, persons needed to meet the constitutional test, not just one. That decision, however, contradicted the overwhelming tide of rulings by the federal courts that says only one person needs to show an injury, and it was not appealed to the Supreme Court. And Jim has, you can talk about, if you want to pursue this, I would have Jim in. He said there was a later decision by the same environmental judge that sort of contradicted the Capitol Plaza ruling of the 20 people, because I think he realized, the judge, right away that, oh, what have I done here? You know, I've kind of mixed this up. I'll stop there. Point is, this is complicated. It's not settled. I think the LERB study group needs to clarify this. And when we do, we will have a clear standard for all A&R permits. People will know what it is, and also hopefully a better appeals process when we get into it.
Go ahead.
Okay, thank you. So just to be clear, what you're recommending taking out all the language in sections 14, 15, and 16.
I would
All
say,
those
yeah.
changes, and then just having this study that's in section 11A. But this, at least the title of this study is Act 250 Appeals Study. And these sections are trying to deal with municipal appeals.
Right.
So do we need to like tweak the study?
I mean, you could, I don't, like I'm saying, we're looking, the group is looking at, so this was Senator Ron Hinsdale before this came up. I guess it's impossible to talk about appeals without talking about zoning and A&R, and if we're talking about all of it, I don't think there's a danger in clarifying it, but we're doing it anyway. We're gonna meet we've had 2 meetings, it's May. The moving, we talked about it at the last meeting, moving the study to November, we're gonna meet that deadline.
You gotta meet the November
Yes.
deadline?
Absolutely, you could have the Lerman, but we talked about it, we're on track.
Even with 35 people or whatever?
Yeah, I know it's gone, I think it's gone pretty well, and the value of the 35 people is, you know, as we've tried to address this issue over the years, and there've been many proposals, is that, you know, you just need so many people, or whether you're like a business attorney, or you're a municipality, or a housing developer, or you're a citizen who's participating, everyone's there, that's why there's so many people.
Yeah.
And I think it'll give a better chance of like success in the end. Even though it is difficult to manage a meeting with that many people.
Sharon?
Well, it's the LERB, and there are 2 LERB members that are doing it, they're doing a good job on my estimation, but so. I don't have a problem clarifying it, but I don't know that, I don't necessarily think it's needed, but, and the date we're on track, we will have I think what you're gonna get is several recommendations, because of the complexity of this, but it'll be well thought out recommendations, and there'll be agreement that each one of them would be legal and would have pros and cons. And I think it's gonna be a big lift for the legislature, for this committee, for the House committees of jurisdiction to decide what to do. But clearly, I think it's a better way than to try to do it, you know, it's try to pull one little thread this year, and you can see. Every time I hear like testimony, it's more complicated somehow.
Can I ask another question? So I thought it was really interesting, your comment, and I'm not gonna paraphrase it correctly, but basically, if we're clear in law what you can and can't do, that limits appeals. Like if you got put an ADU, as long as you have sewer and water and it meets setbacks, boom, can't appeal that because it's very clear. And versus limiting appeals, because I do get really concerned when we're saying, well, in this case, you have due process, and then in this case you don't.
Exactly right.
There's so many implications to that, so.
I think it's really
is that
exciting.
part of what this appeal study is
Yeah,
looking at?
we talked
Like,
about-
how do we-
yeah.
Not how do we limit appeals, but how do we define the things in the law so there are fewer appeals?
Yeah, and it's in Jim wrote about this in his email, Jim is on the appeals group too, but yes, it's very exciting actually. Because it comes out of, like I said, when you look at other states, they haven't limited appeals, they've limited what is involved with permitting. The fact that we're gonna have the tier 1A and 1B maps, like we have the areas where we wanna start, it's kind of like the chip conversation. about where we start with fund, in that case, it's funding for infrastructure, but in this case, it could be, well, if you're in a 1B area, like, we've done, and it's not that we have, the beauty of Act 181, I think, one of it is like, we're doing it through planning. We're saying, we've already taken care of natural resources impacts, we've decided that this is where we want these developments to go. Really, all that's left is building permit, you know, meet the dimensional requirements of zoning, make sure you have water and sewer. And it'll be an expedited review and there's nothing to appeal, basically, and that's about housing.
Yeah,
And I think that that really is, that will really help, and even, and I've talked with Senator Romans-Dale, the issue that you heard from Secretary Moore about wetland permitting, I just feel that's premature, I think we should go big, I think we should have a more rational discussion of all A&R permitting. Like, why can't you have like one A&R permit in these areas, like if you need, you have stormwater, if you have wetlands, whatever the A&R permits, like have one sort of like general A&R permit that also limits appeals, because it'll be, you meet these kind of best practices. And we can expedite all the permitting that way, not kind of picking off one issue and then changing the permitting for that, and. But I think there's an opportunity with A&R permits in these areas as well. And then as we go forward, we could look at the 1A and 1B maps and see how our housing stock is affected. Are we building more housing? Are we getting, you know, more, are we getting more housing available so that meets the demand, and, you know, so the costs go down? We'll have a baseline to look at. But yeah, thank you for like putting it that way. I just, going on the end of the pipe of appeals seems, it's the wrong way. And it wasn't, I spent the weekend doing a bunch of research, and what I found was, and a lot of the legal states, Massachusetts, Connecticut, and New York have really taken the route of limiting what you could appeal. And I think we're doing it in a better way, because they're not doing sort of this smart growth mapping. So I think we are kind of taking it like one more step, you know. But anyway, it's a really complicated issue. I think this language is really confusing and problematic, and I could go on, but I don't know that it would be useful.
I think we have
Just
another
one
question here, yeah.
Is the mapping done?
The mapping is being done.
Okay.
The mapping will be done
So,
by the time you get back in January, the maps will be done.
Which maps?
The 1A, 1B maps will
the
be,
tiers.
yeah,
Tiers.
The tier maps.
Yeah,
Change
but not-
it should be,
But not tier 3, that's gonna take more time.
right, not tier 3, and tier 3 is, this one asked me, in the House about chip, and I don't think tier 3 should affect chip at all, but yes, we don't know what tier 3 are the critical natural resources. They're going to be, you know, pretty limited. You know, that group is going on as well right now. But they're gonna be like our most sensitive natural areas, they're gonna be our most sensitive habitat areas, you know. But I think really for the purposes of the housing bill, I don't think anybody is thinking we're gonna solve our housing crisis by building in our most sensitive natural resource areas.
Well, and coming back to the tier 1A, 1B areas, the just as a status update, I mean, I apologize, I know you're not on the land use review board, but if you happen to know, because part of that was they had to do some rulemaking around or clarification about the application process.
Yeah, no, I think they did, they were adopting guidance, the guidance is done.
Okay, so the guidance is
Yeah.
done, and so do you, and for both 1A and 1B?
I believe so.
Right,
I think that's
do you happen to know if towns have started to apply, you know, to
Well,
put in a request?
I think what's happening is the RPCs are going first, like
Okay,
so they're drafting their maps, and I think you heard some testimony on this, like earlier in the session. The RPCs are on track, and you heard that from like Peter Gregory, Catherine Patrick, and Charlie Baker, and so they're on track, they're gonna go first, they're gonna put some draft maps out there, they're gonna work with the towns. Try to get towns approval, but I don't think the towns really, they don't have a veto, it's really the RPCs will get their input. And then put something forward to the LURB, and the LURB will begin this summer and fall. Reviewing these maps, there'll be public hearings, there'll be public input. You know, it was interesting last year, the debate on Act 181 cut both ways. People wanted to make sure there was enough public input, right? Like, we want more housing, but there was also, I wanna make sure that like towns don't get steamrolled, and people, property owners don't get steamrolled, right? Because there are people who own property within these growth areas, and some people might be like psyched about that, and some people might be less psyched about that, you know? They also don't get a veto, but they get their own version of the due process, but it's a planning process. And that's, you know, I think, one of the things about Act 250, when Act 250 was enacted in 1970, it was supposed to be a planning and development law, and it's become really a development law, like a permitting law. And I think this brings planning, and the idea is to solve these problems in the planning process, so then you don't need much of a permit. And you don't need Act 250, so in the 1A and 1B, you won't need Act 250, and there should be a limited zoning permit as well, I think. If that's a change that the legislature can make, you know, to look at next year, I think, but. Yeah, so I'll stop there, I think, I would say if you are considering adopting any of this language, you should have Jim in, he's available tomorrow if you want to hear from him. He's on the appeal study committee, so we're just sitting next to each other on Monday talking about all of this, so. David Mears, and Ron Shems, who have a lot of experience with it, they also sent a letter in and they could come in but only if you're gonna take it up, it depends, it's up to you, you know, if the committee's gonna continue to pursue this, I would hear from people.
Yeah.
People like that.
Well, thank you, appreciate that, I particularly appreciate your big picture perspective on how other states are doing this and what this is trying to do and just other options, I appreciate that, so.
Yeah.
Thank you, and I would love to have I realize we are missing a couple people right now, but would love to at least have a conversation about what we're gonna do with this language moving forward. So we'll do that after we hear from Mr. Weiss.
Yeah, thank you.
Thank you.
Yeah.
Sure.
Welcome.
Thank you. Good morning. I am Thomas Weiss, a resident of Montpelier, and thank you for this opportunity to speak to you this morning. I'm a civil engineer with experience in trying to understand and apply rules, regulations, and statutes, and I also participate in Montpelier's mostly annual updates to zoning bylaws. And I'll be speaking from those aspects. This morning, I'll talk about section 17 of H 479. That's the section that Mr. Kowski indicated hadn't received much testimony, and it's about whether or not to have hearings for required amendments to zoning. And I'm talking from the version that came over from the Economic Development, Housing and General Affairs. In section 17 is a notwithstanding provision that supersedes all other laws, and my letter is on your site if you want to refer to it later. Anyway, section 17 is a notwithstanding provision that supersedes all other laws, and in my opinion, notwithstanding provisions can have serious unintended adverse consequences if you don't know everything that's going to get swept up into that. And so the use of notwithstanding provision should be strictly limited, and I think its use in section 17 is unjustified. What it actually says is, notwithstanding this section, any other law to the contrary, for bylaw amendments that are required to comply with amendments to this chapter, no hearings are required to be held on the bylaw amendment. Last week, you heard from Samantha Sheehan from all the cities and towns, and she gave me some of the language that I need in order to present this more clearly than I might have otherwise. She talked about section 17, and she supported the option of not requiring public hearings for zoning preemptions. She used the term zoning preemptions. And section 17 is overly broad. It would apply to all required changes, whether they are preemptive or not. Nowhere does section 17 limit the notwithstanding part to preemptive changes. And I am considering preemptive statutory amendments as those that specify the details of the required provisions of bylaws. They automatically supersede municipal bylaws, even if the municipality does not amend the bylaws. But it's much clearer to amend the bylaws so that local people know exactly what is in there instead of zoning administrators saying, oh, well, we didn't change this yet, you have to go to the statute. And some examples of preemptive statutory amendments I'm taking from last year's House bill. One is requiring that in any district that allows year-round residential development, duplexes shall be an allowed use with dimensional standards that are not more restrictive than is required for a single unit dwelling, including no additional land or lot area than would be required for a single unit dwelling. That's pretty specific, pretty detailed what you have to do. Another example is requiring that in any district that is served by municipal sewer and water infrastructure that allows residential development, multi-unit dwellings with 4 or fewer units shall be a permitted use on the same size lot as a single development unit dwelling, unless that district specifically requires multi-unit structures to have more than 4 dwellings. So again, pretty specific. And now I'll give some examples of non-preemptive statutory amendments. They would be those that require changes to the bylaws and that leave the details to the municipality. It is inappropriate for a planning commission to waive hearings on these non-preemptive changes. The public should have the right to be heard at hearings in order to flesh out the details of the change and in order to provide input on how they're regulated in the bylaws. Here are some examples of non-preemptive statutory amendments. The planning commission should not have the authority proposed by section 17 to waive public hearings to certificates. One is hotels and motels converted to permanently affordable housing developments. They were added last year to the uses that may be regulated only in a limited fashion. And if you're considering existing buildings, those aspects that could apply or could be regulated by the town include traffic, noise, lighting, landscaping, and screening requirements. So, and I'll leave it there for a moment. Another example is requiring that in any area served by municipal water and sewer infrastructure that allows residential development, bylaws shall establish lot and building dimensional standards that allow 5 or more dwelling units per acre, each allowed residential use, and also density standards for multi-unit dwellings should not be more restrictive than those required for single-family dwellings. And that's from the 2023 House bill. The bylaws are required to establish dimensional standards, while the specifics of the dimensional standards are left to the municipality. A third example is changing a bylaw option to a bylaw requirement. I didn't find one recently in statutes, and I'll give you a hypothetical example, would be requiring bylaws to regulate uses within a river corridor. Current statute makes regulating those uses optional with bylaws. So it's possible, because of the severe floods over the last 15 years, there might be such an amendment. Public input would then be necessary in order to develop a bylaw amendment to regulate the types of uses and conditions for use within a river corridor. So now that I have explained the 2 types of required amendments, I provide an alternative, section 17. It would allow waiving public hearings only for bylaws amendments incorporating the preemptive statutory amendments, and it would not allow waiving public hearings for non-preemptive statutory amendments. And the letter contains the text. I won't go over it as that's in line. Of course, it could just eliminate section 17, and public hearing would allow the public to propose additional changes to the bylaws that might change the boundaries of zoning districts in which the preemptive changes are required. So they have to do the preemptive changes, but they could adjust where they have it. Anyway, thank you for the opportunity to speak to you this morning.
Thank you. Any questions for Mr. Weiss?
No, thank you.
Really appreciate your attention to particularly this section and thinking through the consequences of taking out these required use.
Yeah.
So, we appreciate thinking of this.
So my urge is that if you leave it, if you leave the concept in, that you narrow the scope along the lines that I suggested. And I'm not sure that the words would actually pass the council muster, but it might be a little adjustment.
Mhm. Okay, well, thank you so much.
You're very welcome.
Yes. All right, so we have a little bit of time and I'd love to chat about where we want to go with this, in particular. Would love to, hear your thoughts, but I'll just start off by saying my inclination with all of this is to just take out sections 14 through 17. I was very much appreciating the testimony from Mr. Groveman, but actually from all the people that we heard today. Mr. Weiss on 17 and you know, Judge Zone's concerns about the potential widening. So my sense is that we should let the LURB study go through, not make any changes in the meanwhile. I was interested in your comment though, Senator Hardy, about potentially adding some clarifying language to say we you know, recognizing that this is that their charge is really about Act 250, but it may have some implications for municipalities, municipal appeals. So to the degree that I mean, it sounded like from your testimony, Mr. Groveman, that it would not be super far outside of the box to.
Yeah, no, we had a
Extend
whole,
that.
we probably talked more about municipal appeals on Monday than we did
Really?
anything else, so.
Okay, so if that is, you know, something that they're even already talking about, just to make it clear that we do hope to have some recommendations from them about the municipal process as well. And I'll just say, you know, outside of that, it would be great if there was some consistency between the Act 250 appeals and the municipal appeals to the degree to which that's appropriate. I think that is helpful. So that's where my sense is. How are you all feeling about that?
Yeah, I think that based on the testimony we've gotten, it feels like this is not quite fully baked.
Yeah.
And I have concerns about, I think the who's in, who's out, the aggrieved, the injured, and the constitutional concerns. I think that I completely agree with the Act 250 study, and we could put something in about essentially they may or add, but I also would add, it sounds like the A&R appeals also, like, you're also.
Yes, I agree with that, yeah.
Yeah.
We're talking about them all and, yeah, so you were gonna add municipal, I agree, add A&R.
Yeah.
Yeah, those underlying.
More simplified and consistent across the 3 areas or something like that.
Yeah, I think that's great. So, any thoughts?
No, I actually like. Well, it's just, you know, still on the right path. And, you know, any idea what you're gonna do with it, where it's moving?
I mean, we are gonna be making some changes and we'll see where it goes.
Are you okay with taking out the language in those sections because it's not fully, yeah, okay. Good.
Okay, great. So, Alan, how does this, from what the conversation that we just had, do you feel like you have clarity for another draft?
So you're gonna take out sections 14 through 17. I don't know what you decided for 18.
Okay, so for 18, which is about the LURB study, if we could add some language that asks them to also look at the municipal permit appeals process as well as the A&R permit appeals process. And streamlines it, hopefully adds some consistency to the appeals process for all 3 of those categories.
Yeah, something like the study may also include recommendations to do what the chair just said, to make the appeals process simplified and consistent across those three areas. But I think you can, we just put it in as a menu, that
Sure, that's fine,
if they're doing it already,
yeah.
but. What do you think, John? Do you think we should put shall or may?
And I would vote for shall, because I think
And you,
you wanted to happen, and
Okay.
I think. Yeah, I think it should happen, so.
Mhm.
okay,
So I mean, the current directive in this is the report shall at a minimum recommend the following things. So that's why I think they are already looking at other things.
Mhm.
And number 4 is a catch-all. So,
Number 4.
yeah, on page 34.
but
So maybe adding. Oh, well, if we want to be specific about this, maybe we could, either add a 5 or bump 4 to 5 or, to add this specific request about the other types of appeal processes. Okay, and then Mr. Weiss, you had a further comment?
What you're discussing seems to be, to me, already in one. Because one talks about whether to consolidate appeals with the land use review board or to retain the consolidation board. And it specifically mentions chapters 117 and ANR fields. So whatever gets added, I would just be integrated into one.
Into one.
Yeah, I mean, that's, I think Mr. Weiss is correct, I mean, that's why I said we couldn't, we were already charged with looking at the whole system, and if you're gonna talk about consolidation. Yeah, you gotta talk about the whole system, and. So I think that's accurate what Mr. Weiss said.
The one concern I have with that is I don't think we would want municipal appeals to go to the clerk with me.
Well, I mean, that's part of the discussion, you know, and I think you wanna let that discussion go on, and I think that there are people who agree with what you just said, Senator Hardy, but I think that the learn itself is like, kind of like, I'm curious about, like, the land use experts, would it be more efficient?
Okay,
So I at least let them, let it
let them
be
have the
considered, yeah.
conversation. Okay, that's fair. I just don't know enough that was my just gut reaction, but maybe I could be convinced otherwise.
There are many people who share your gut reaction. Others, it maybe could be better, but yeah, no, so we've already had those discussions, and it's been interesting, and.
Okay,
Yeah, so I would, it just give more options for you to consider.
yeah, I mean,
Sure.
you know, go ahead.
Well, so under one, it does say whether to allow consolidation of appeals at the board. Or the environmental court.
First part,
Yeah,
which
okay.
is in, I think it's A itself, is whether the land use review board should take over appeals of Act 250 permits. And then it adds all of these other considerations as to, in one, handle the other types of permits, should they be consolidated, remain consolidated as they are now with courts, whether they're consolidated with courts or land use review board.
I think it might be fine. I think my reaction about changing this was just because it's titled Act 250 repeals and.
But it is baked in.
Or appeals, but it's baked in, yeah, so. I think it's
Okay, so maybe it's fine.
changing the title or just ignoring the title. I can do that.
Yeah, if you went back into the time machine, it was not the right title, I think. Last year.
Yeah,
We can leave it alone.
okay, all right, that's fine with me.
You're in the room, John, and you just have to be.
I'm in the room, Mr. Weiss, in the room, 33 other people,
Or on,
That sounds super efficient.
right, or on teams.
and it breaks out about 50-50.
So I guess our request for another draft is just to remove sections 14 through 17. And we'll leave it at that for now. Okay. And actually, I do have a question. The brownfield section, do you know who the attorney was for the brownfields? Is that,
Okay.
oh, that was a great, okay. See if we can get. Cool, thank you so much.